Each year in the UK, there are over 500,000 violent crimes where the aggressor has been drinking. Sometimes the victim's been drinking too. In many cases, the offence wasn't planned, they'd just gone out to have a good time with their mates. But after a few drinks, behaviour changes. People get more angry, misread the signs, or think they're standing up for themselves or someone else. This conversation between two young lawyers and young adults looks at the possible effects of causing a fight or injury when drunk on that person's life. We've tried to capture some of the questions and the answers that arise too.
Hi, I'm Brooke.
And I'm Maeve.
And we're both criminal solicitors working at Kingsley & Apley law firm in London. We specialise in criminal law and work with young people and adults every day who have found themselves caught up in the criminal justice system.
We're going to go through a case study, which is based on a sort of circumstance that we would get almost every day. So Brooke will take us through the facts.
Sean and his friends have been pre-drinking heavily before heading to the club. Sean is drinking there for a couple of hours in the club with his friends and having a really good time. When the club closes, Sean goes out to the front of the club to get a cab home. Whilst he's waiting, he thinks someone beside him knocks into him. Sean then pushes this individual back and believes that he hears the person shout, "I'm going to get you for that," and sees him lunge towards him. Sean then punches this person in the face, knocking them to the ground. Sean is arrested and the person he punched is taken to hospital. The victim suffered concussion, had severe bruising around his eyes and a broken nose.
The set of facts that Brooke has just read are pretty common, and on our day jobs we work with people that have found themselves in these sort of situations all the time. Unfortunately, drugs and alcohol do play a large part in a lot of violent crimes that we see, and 47% of all violent crimes that take place in England and Wales happens when the offender is intoxicated.
We're certainly not here to tell you not to drink alcohol, but instead we want to give you an understanding of how the law interacts with alcohol in England and Wales. We want to equip you with the knowledge to help you make informed decisions as you go forward onto university or work, travelling, whatever your plans are. We believe it's important for young people to understand their rights and to help them make informed decisions as they go forward.
And I think it's worth saying from the outset that in England and Wales, the law does treat you differently if you're a child or a young person. So if you're under the age of 18, you are considered a child in the eyes of the law. This means that the approach the courts take to punishment tends to be more focused on rehabilitation, which means trying to stop that young person commit a crime again. However, that doesn't mean you can't be arrested, charged or convicted of a crime when you are a child, and that can have quite big impacts on the rest of your life, be that employment or even getting a visa to another part of the world. So as Brooke said, we really just want to focus on letting you know the law so you can make the right sorts of decisions for you.
So let's talk about alcohol. If you commit a crime whilst you're drunk, can you use the fact that you're drunk as a defence in law? Why don't you discuss and come back to us?
Hopefully you got the correct answer, and that it's not a defence in law in England and Wales to be drunk when you were committing an offence. And that's not a defence per se, whether it's voluntary or involuntary. If you're like Sean and you've drank loads, it's not going to be a defence to say, oh, well, I don't remember it, I was too drunk. It's still an offence. Interestingly, in some circumstances, being drunk can actually be an aggravating circumstance. And an aggravating circumstance is one that may lead to a harsher sentence or punishment if it's taken into account by the judge.
Today we're going to be focusing on basic intent crimes. These types of crimes include assault, ABH, so actual bodily harm, or taking a vehicle without consent. For basic intent crimes, voluntary intoxication is never a defence. So for example, if I go out to a party tomorrow and drink 4 glasses of wine willingly, and then I decide to take someone's car without asking their permission, I can't rely on the fact that I was drunk and might not even remember stealing the car.
So to go back to the facts of the case study, a lot of people in Sean's position who, end up in a bus stop may say that they were acting in self-defence. And this is really important because self-defence is a defence to the offence of assault.
Let's look at self-defence and its definition in the UK law. A person may use force as is reasonable in the circumstances in the prevention of crime or in effecting or assisting in the lawful arrest of offenders or suspected offenders of persons unlawfully at large.
So that might apply to this situation, and we would have to get more evidence of what actually happened in the fight. So say, for example, we get our hands on some CCTV, which shows that Sean was stumbling around and he was the one that maybe threw a sloppy punch at the other guy first. Now, Sean, in his drunken state, may well have fully believed that he was acting in self-defence. However, mistaken belief, because of voluntary intoxication, is not a defence. So, and I know that's a little bit wordy, but if I get so drunk that I think I'm being attacked, and even if that is a genuine belief, I still don't have a defence in law.
The law in this area is obviously quite complex, so just let us know now if you have any questions.
Hello, my name is Ellie, I'm 17, and my question is, why would you be treated more harshly if you were drunk when committing a crime?
Maeve touched on it earlier actually, where she talked about aggravating and mitigating circumstances. So if you plead guilty or you're found guilty and you come to the sentence, being sentenced by the judge, the court will look at various mitigating or aggravating factors. So for example, an aggravating factor or another aggravating factor could be where you've deliberately targeted a vulnerable individual, or whether you have any previous convictions for similar crimes. So being drunk in some cases would be considered an aggravating factor, and that means that your sentence might be slightly harsher. Your sentence might be slightly harsher. Some mitigating factors are whether you're remorseful for the crime that you've committed, or whether you have attended a course or tried to rehabilitate yourself in some way.
Hello, my name is Allegra and I'm 17, and my question is the credibility of the witness or victim affected if they are intoxicated?
That is a really good question, and just to give context, so when the police or the CPS, which is the Crime Prosecution Service, and they're the lawyers for the prosecution essentially, they have to decide when making a decision to charge someone if they've got enough evidence. And of course the victim or the complainant's statement will be a really key piece of evidence. If the person that is a complainant doesn't remember anything, or their statement is a bit patchy, then the strength of that evidence is not great. Now, that's not to say that you cannot be a victim of crime if you are intoxicated and drunk yourself. But what usually happens in these circumstances is that there's loads of circumstantial evidence. So CCTV of the event, if the person goes to hospital, other witnesses. While the victim's account is extremely important, the police and the CPS will be looking at all these other factors to try and ascertain whether there's enough evidence to prove that an offence happened, and that 100% is part of that.
Hi, my name is Jude and I'm 16, and my question is, what is the difference between ABH and GBH?
Okay, so they're two different separate offences. ABH is short for actual bodily harm and GBH is grievous bodily harm, and the law treats them very differently. And the difference between ABH and GBH essentially is the level of injury that's caused to the victim. And there's different sentencing guidelines, which we talked about earlier, and you're treated much more severely, I think quite obviously, if the victim is got grievous injuries. Actually, if you cause grievous bodily harm with intent, so if you mean to do that, you can face up to life imprisonment. So it is really very serious. But with offences against the person, there's a whole sliding scale going from, common assault right the way up to grievous bodily harm. And it's usually something that will be spoken about by the defence and the prosecution when trying to say what is the correct charge for the level of injuries caused to the victim.
Hi, my name's Eva and I'm 17 years old, and my question is, what exactly would Sean's sentencing be?
Say, for example, when we look back at the case study, that the offence that Sean would be charged with would be actual bodily harm. When being sentenced for that crime, the judge would look at a variety of factors. As we talked about earlier, he would look at the aggravating and mitigating circumstances, and the judge would take into account lots of various other considerations. I think the lowest sentence that you can receive for ABH is a fine, and then it goes all the way up to 3 years in custody. So quite a big range, so it would depend on lots of different factors.